I got a lady, name is the upper echelon, she a debater, baby. She can give it to you straight, no chaser. She got the smarts, she got the heart, she got the confidence, baby, she the upper echelon. You know you intimidated, stupid can't play with smart. She got the smart, she got the heart, she got the confidence, baby, she the upper echelon. You know you intimidated, stupid can't play with smart. 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 I got a lady. Name is the upper echelon, she a debater, baby. She can give it to you straight, no chaser. She got the smarts, she got the heart, she got the confidence, baby, she the upper echelon. You know you intimidated, stupid can't play with smart. She got the smart, she got the heart, she got the confidence, baby, she the upper echelon. You know you intimidated, stupid can't play with smart. 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 I got a lady. Name is the upper echelon, she a debater, baby. She can give it to you straight, no chaser. She got the smarts, she got the heart, she got the confidence, baby, she the upper echelon. You know you intimidated, stupid can't play with smart. She got the smart, she got the heart, she got the confidence, baby, she the upper echelon. You know you intimidated, stupid can't play with smart. 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 Stupid can't play with smart.
Welcome back to the Upper Echelon Podcast, where we keep it real and we keep it jiggy over here. Because why? Because we ain't never, ever scared. Hit the like button on your way in. Make sure that you subscribe to my channel if you have not already. Also, hit the notification bell down there at the bottom so that you can be notified of any time that I go live in the future, or anytime that I post content in the future. You guys, this is not going to be the longest live. I know I had you guys wait for a while, and I was going to get started at like 10:45, 10:30 Central Time, but child, I said, I'm getting tired, and I know my people are getting tired, so I'm not gonna make them stay up all night long and then get started at 10:30 because I know that y'all got things to do, y'all got jobs, and y'all got business to take care of in the morning. So I said, why not get started now? Because child, I was about to go lay down. 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 So I said, let me go. I said, let me go ahead and go live because I'm getting tired and I know they is going to get on my ass if I do not hit that doggone live button right now. I seen Comic Collective in the chat talking mess, snitching on me. Trina said, and it's raining out here, y'all. So you know that's like the best sleeping weather. So I'm like, it's all calm and relaxed up in here. So let's get started, y'all. Let's get started. What are we going to talk about today? So today, what we're going to talk about is what is going to happen. Now, how many days we got left, y'all? Let me look at my calendar. We got 5 days left until the next court date, y'all. 5 days left until the next court date. So what I want to do tonight is go over a couple of things. We're going to talk about what's going to happen at the upcoming court date, what kind of have been presented already, and what not to expect at the next court date. Okay, so that's what we're going to be talking about. We're also going to be talking about a small portion from the medical examiner's report. Oh, out just hit, or if the audio is good, hit 1. If the audio is bad, hit 2. So good, 1 for good, 2 for bad. Okay. But for right now, I think I'm all right. So let's go ahead and get started. Let's pull up a couple of things. We're going to talk about what happened at the previous court date, you guys. And then I like to start it out like this. Somebody said your sound went out. 2 for bad, 1 for good. 2 for bad, 1 for good. So 1 for good, 2 for bad. Okay, so we got to see 1s and 2s, so I'm confused. But I see a majority 1, so I'm gonna assume I'm okay. Okay, it went out, you guys. I don't know what happened, but it went out momentarily. Okay, y'all can stop dropping numbers now because I think I'm good. Okay, so just let me know. Matter of fact, okay, I see y'all. So let's go ahead and pull this up. The first thing we're gonna pull up is the court docs from the previous court date, you guys. And then after that, we're gonna get into the small portion from the medical examiner's report, where it talks about a small piece of red fabric on a bullet that was recovered from Romika, okay, by the medical examiner report, and what that could possibly mean for Quadasia's case. Okay, so let's pull up page 1. Okay, here we have it. Let's see. Okay, so we're just gonna read over the transcript. I'm gonna be looking at my other device to make sure that my audio is good. Again, 1 is for good, 2 is for bad. Let me know if it's good or bad anytime the audio changes in any way. So, of course, this is when the hearing began. The court, Quadasia Johnson. I want to start out before I read this. All of this is the actual transcript from the previous court date. Okay, I'm not adding anything in. I'm not taking anything out. We only present facts over here. We don't give our opinions, our feelings. We don't be over here, crying and complaining about shit because it's not going our way. We simply read the document, so nobody can say I'm skewing any evidence. Nobody can say that I'm just giving my opinion because we have the black and white here on the screen, right? So let's get into it. Welcome in everybody. Hey Tony, Bailey. So the court, Quadasia Johnson. Miss Williams, for the record, Ari Williams, Ari spelled A-R-I, Williams, common spelling on behalf of Ms. Johnson. I can give you a brief update, Judge. So Ari is ready to give a brief update. The court says, okay. Ms. Williams says, I just want to put on the record the last, and this is to let you guys know really what to expect next court date, okay, you guys? Ari says, I just want to put on the record the last court date we talked about consumption of DNA. We were looking to have an expert present. I don't think we talked to the state. We're not going to have an expert. The DNA kind of goes straight towards our defense. So we won't have an expert there. I let the state know they can go ahead with the consumption of the material. We have no objection to that. We did receive some discovery today, a phone dump. We got that today, so we'll download it and we'll review it. I don't know where the state is with discovery though. And then the prosecution jumps in and says, which is why he got a little jazzy there, y'all, with Ari. He says, which is why he usually asks me to give the update. And then the judge says, all right. Prosecutor says, that's correct, Judge. She, counsel, contacted me and let me know that she was changing her position on the expert. I did ask her to put that in writing and she did. Okay, so I'm gonna stop there before we go on to the next page. So, hey, Gossip and Giggles. Hey, everybody coming in. So, on this particular document, Ari is deciding to go ahead and jump in first and give her update on where they stand, because this is basically a status. The court is asking Ari, does she need, or is she still in agreement with an expert? She says no, that she doesn't need an expert because the DNA goes straight to her defense, okay, whatever that means. So she's agreeing to the consumption of DNA. Now, a lot of people, if you guys don't know what consumption of DNA means, the consumption of DNA basically means that she's agreeing that the DNA be destroyed. Okay, so that sounds crazy, right? So, but let me explain. When DNA is tested, the DNA is altered and destroyed. When you test DNA, the consumption of it means the to consume it, meaning it will no longer exist after it is tested. So she is agreeing for the prosecution to hand that DNA evidence to the Illinois State Police for consumption. So she's agreeing to that. Is everybody following me? So let's go on to the next page. So Ari is agreeing to the consumption of DNA evidence. Let's go to the next page. Okay. Okay. So before this page began, I'm going to finish reading what the last page says so that we can be on the same page here, y'all. So what happened before this page came up is Mr. Kostopoulos, who is the prosecutor, said, that's correct, Judge. She, the counsel, contacted me and let me know that she was changing her position on the expert. I did ask her to put that in writing. She did. So I've notified the Illinois, now we're on this page. So I've notified the Illinois State Police if there's going to be consumption, that they can go ahead and do the testing. In regards to outstanding discovery, I did tender 2 inventories to counsel today, comprising of 2 different phone dumps, one on a Blu-ray and one on a flash drive. There are still videos outstanding, some supplemental reports and progress notes, potentially some meds, and then the DNA. Gunshot residue and ballistics testing is outstanding. So he's saying that given the discovery that's outstanding, okay? The court says, give me again what's still outstanding. The prosecution says there are potentially some meds. The judge says, okay. Prosecutor says some videos, a lot of videos. The judge says yes. Prosecution says some reports and general progress reports, and then ballistics, DNA, and gunshot residue. The court says, or the judge says, all right. And Ms. Williams, do you not wish to have a DNA expert present, and you do not object to consumption? Is that correct? Miss Williams says, no, I don't object. So Ari is saying here that she does not need a DNA expert present, and she's also saying that she is not objecting to the consumption of DNA evidence, meaning that that gives the prosecutor the go-ahead to go on and send the DNA over to the Illinois State Police for testing. Prosecution then goes on to say, Judge, for all purposes of picking the next court date, the DNA will be on the May grid. So let's go over to the next. Oh, thank you, Nina. Let's go over to the next page, you guys. So let's see. Okay. We did that one. Okay, let's see. See if this is it. Okay. Give me 1 second, y'all. I'm going to take down what I've already read, and then I'm going to put up. Okay, here we go. Okay, so they said it's going to be on the May grid, so there will not be a report until early June. You guys, I do have a goal of 10 super chats or super stickers. Thank you so much, Erica. I appreciate that, hon. Prosecution goes on to say, I understand you may want an earlier date. I'm just letting you know. The court says, what day would you like, Miss Williams? Miss Williams, who is Ari, says, Judge, I do know the state informed the court that there's a lot of videos that are outstanding. The videos that we subpoenaed. It's just misspelled because I had to alter this for my watermark. I'm almost certain we did send that to the state. I know there's additional videos. If not, we'll make sure we send everything over to you that we have. Prosecution says the only videos I've gotten from you are the ones that you use in your petition for relief. Now, Ari said that's all we have. This is sad. Prosecution says, so then you're missing all the body cam, which I'll get to you because I think I received some of it. So let me go through it and I'll get it to you by the end of the week. So then Miss Williams, Ari, says, our position had body cam also. So we sent that over as well. Now, prosecution says, you said everything was attached to your motion, but your motion had like 5. Okay, so let's go to the next page. Let's see. Okay, hold on, y'all. Let me pull it up. Hey, everybody coming in. Let me pull up this next part to the document, y'all. Give me 1 second. So we can make sure we read the whole thing. This one is short. Okay. Well, you know what? I think I'm just going to have to read from here what it says. Hold on 1 second. And then I'll just show it later once it uploads. It's just taking a minute to pull up. Okay, so the last part of the document says, in the email. Okay, so the motion was presented with the clips. This is what the prosecution is saying. I'll make sure the state gets it today, Judge. The judge says, very well. Ms. Williams said, can we have April 1st? I know the DNA won't be back until June, but I would like to take April 1st. April 1st, that's fine, the judge said. By agreement, April 1st, 2026, that will be from the meds, videos, gunpowder residue, ballistics, DNA, gunshot residue, understanding that the DNA is on the May grid. Then prosecution says, I don't expect by April 1st either the trace chemistry or the ballistics to be done either. Ari says, I know that she's in custody. I just want to keep the dates as short as possible. The judge says that's fine. Now that ends the what happened on that date. So now we know that on April 1st, what we're not going to be seeing is we're not going to see the DNA evidence, okay? The meds will be outstanding. So whatever evidence they have as far as meds will be outstanding. Trace evidence will be outstanding, but by April 1st, that date is for the videos that they're supposed to be showing. So the videos that they're supposed to be showing, I believe gunpowder residue, and I think by then the phone dumps should be available as well, because they said that they had it on Blu-ray and they had it on a flash drive, so that should also be ready. So that's what's happening April 1st. Let me look at some of my comments really quick. Sounds like Ari needs more money. I don't know what it sounds like. It sounds like she doesn't have anything to me. I don't. It's almost like they begging her for the evidence. It's like they're begging her for the evidence. Where's the video? Oh, I turned in the video. Oh, but we only have this. Oh, but I'll make sure you have. It's like she doesn't have anything, so it's like she's kind of trying to drag it on. That's what it seems like to me. So the court says by agreement, April 1st, that will be for meds, videos, gunpowder residue, ballistics, DNA, and gunshot residue, with the understanding that DNA is on the May grid. So the DNA will not be ready on April 1st. There will be some discovery presented on April 1st. DNA trace, chemistry trace evidence will not be available or ready either. Shout out to Nakia Daniels. Shout out to Dr. Q, Mav Deuce. Josephine, thank you so much for that 14-month membership. A Stokes, thank you for that super chat. I appreciate you. Erica, thank you. A Stokes, thank you for that 16-month membership. You guys, what we're going to get into now, I think I said hi to Nakia Daniels. I want to talk a little bit about this motion that Ari put in those exhibits. Now, I want to give a shout out to Keys, because I want to go over this, and then not just Keys, because I think Trina posted it too. I have it as well, but it's no point in posting it because everybody's seen it already. But this is the motion from the appellate court. Now, this was entered on March 19th. And it states word for word, presiding Justice Mitchell, Justice McKeeva, and Justice Odin Johnson order as follows. On the court's own motion, it is hereby ordered, appellant is directed to supplement the record with any exhibits, video, or otherwise, that were before the circuit court in her pretrial detention hearings on or before March 25th, 2026. Appellant Johnson shall file these exhibits with the clerk of the circuit court. The clerk of the circuit court shall then immediately certify and transmit to the clerk of this court a supplement to the record on appeal, with any video exhibits made available in case center. Upon receipt by this court, the supplemental record will be treated as having been filed with leave of court. Now, we've already seen the exhibits that Ari has presented. And so basically what this document is stating, for lack of a better term, or I'll say in layman's terms, is they're saying that what she's already provided, or the exhibits that she's already attached to the appellate court, was not enough. So they're saying that all of those exhibits that everybody's been showing, and I may show them again. Matter of fact, let me see if I can pull them up. You guys have seen them a million times. I don't think it's necessary, but let me go ahead and pull them up real quick. Let's see. All of the exhibits that everybody has been going crazy over, like the call logs of her calling or incoming, outgoing calls, social media, and all of those things that people have been like going crazy over, like it really matters. The appellate court is actually saying it really doesn't matter. And they're saying that what she submitted just wasn't good enough. So she has to submit whatever videos, whatever evidence that she presented in those previous court hearing, in the previous court hearing, at her pretrial detention hearings, she's going to have to present those things and everything that she presented prior to the appellate court. So let's see if we can go ahead and pull it up, even though I'm sure you guys have already seen them, like I said, a million times. Now, the exhibits that Ari entered were entered, they were filed March 20th. Okay, let me pull this up. Let's see if that's the correct date. Hold on one second. Let's see. Okay, so on the document that I'm showing on the screen, that was filed March 19th, right? So March 19th, it was filed that she was to add any exhibits that she needed to add onto that motion. So let's go ahead and pull up some of the exhibits that she went ahead and filed on the, I don't want to show my, let's open it up in Doc Hub. Shout out to Hot Wings Lover. Thank you, boo. What up, Upper, in the entire chat? Hey, Love Flock, So Pretty Germ. So Pretty Germ said, right, if it's self-defense, show us. She can't show us nothing. Now, no, she feel crazy. This really could take some years. This is actually what I'm telling people, or what I have been telling people, is that cases like this, just to simply wait for a trial, is gonna be some years. So this is the reason why her attorney is going so hard to try to get her out of detention, because she wants to go to trial, and it's gonna be a while before she gets there. You have people that's sitting in Cook County Jail for 2, 3, and 4 years just waiting on trial. So that's what she's trying to get around, because she knows she's going to be sitting down for a long time. So she's trying to at least get her out on a less restrictive monitor. Let me see. It's evident her case is weak. It is weak. So let's pull this up really quick. We showed this already, but I'm gonna pull it up again. So let's see. Okay, so the motion was filed by the appellate court March 19th. Now, on March 20th, she filed her exhibits, and these are the exhibits that everybody's been going crazy over right here, all of these. Okay. So the court is asking for videos, everything that she presented, and this is all she has. This is all she has. So let's take this down. Weak. It's evident her case is weak. Very. Let's get into this, you guys. One thing that I saw on her motion, something that I noticed on her motion was really interesting that I want to bring up to you guys. And then I want to talk about why I think that it's not going to work. Well, now I ain't even going to say thing. Why I know it's not going to work. So let's get into that. Why I know that this is not going to work in her favor. Now, this is what it says on a part of her motion. Okay, y'all. So let's just read a little bit of this really quick. Thank you guys for giving me the 7. I'm up to 7 super chats and super stickers. I appreciate y'all. So she says on page 12, section B, that the state failed to prove by clear and convincing evidence that Ms. Johnson poses a real and present threat to the safety of a person or persons in the community. So she goes on to say that the state failed to prove by clear and convincing evidence that Ms. Johnson poses a real and present threat. A court may consider factors articulated in 725 ILCS In addition to the specific articulable facts of the case when determining whether a defendant poses a real and present threat to the safety of any person. She goes on to say Ms. Johnson is a 31-year-old pregnant woman and a current mother of one. She has lived a very law-abiding life. Ms. Johnson ran a successful, lucrative lash business and earned acceptance into school to become a dental assistant. Besides misdemeanor convictions, one of which was a traffic conviction stemming from 10 years ago, Ms. Johnson has not been arrested, charged, nor convicted of any violent crimes. Ms. Johnson is not a person of violent character. In fact, Ms. Johnson, well, she was that day. In fact, Ms. Johnson has been readily compliant with law enforcement and the subsequent investigation into this case since the incident took place. While on the scene, Ms. Johnson did not flee or evade arrest or prosecution. Most notably, Ms. Johnson spent approximately 87 days outside of custody from September 8, 2025 until she was arrested and charged December 3rd, 2025. During those 87 days, Ms. Johnson did not reoffend, nor did she attempt to leave the state of Illinois. The record completely devoid of evidence illustrating that Ms. Johnson poses a real and present danger or that she would fail to comply with any court-imposed orders or conditions. Further, a finding of dangerousness alone does not automatically warrant pretrial detention. And then she mentions People versus Martinez. Subsequently, the fact that a person is charged with a detainable offense is not enough to order detention, nor is it enough that the defendant poses a threat to public safety. In believing that Ms. Johnson was emboldened by her CCL, the state completely overlooked and ignored the imminent threat and great bodily harm that the deceased imposed on Ms. Johnson on September 8th. The fact that the deceased was unarmed does not negate the incredible and imminent danger she imposed on Ms. Johnson, nor does this fact negate that the deceased was indeed the aggressor on September 8th. In fact, under the Illinois law, where it is clear that the aggressor is capable of inflicting serious bodily harm on the defendant without the use of a deadly weapon, and it appears that he intends to do so, that is not necessarily that the aggressor be armed for the defendant to employ deadly force on self-defense. So this is not going to work, and I'm going to tell y'all why. Let me pull something up real quick. Because she brings up 725 ILCS. So let's pull it up. So this is the law code that she's referring to. Let me go ahead and switch over to it really quick. So this is the law code that she's referring to. Obviously, it's really small, so y'all are probably not going to be able to see it unless you pinch the screen. But she refers to this law code where she says that a court may consider factors articulated in 725 ILCS. Okay. And this is what it says in the code that she stated. Let's see. It says here, the defendant is charged with a felony offense other than a forcible felony for which, based on the charge or the defendant's criminal history, a sentence of imprisonment without probation, periodic imprisonment, or conditional discharge is required by law upon conviction. And it is alleged that the defendant's pretrial release poses a real and present threat to the safety of any person or persons in the community based on the specific articulable facts of the case. So let's go down. And then goes on to say, the defendant's pretrial release poses a real and present threat to the safety of any person or persons or the community based on the specific articulable facts of the case. And the defendant is charged with a forcible felony, which, as used in this section, means treason, first-degree murder, second-degree murder, predatory criminal sexual assault, aggravated criminal essay, armed robbery, aggravated robbery, burglary, where there is use of a force against another person, residential burglary, home invasion, vehicular invasion, aggravated arson, aggravated kidnapping, aggravated battery resulting in great bodily harm or permanent disability or disfigurement, or any bodily harm or permanent bodily harm, other felony which involves the threat of or infliction of great bodily harm or permanent disability or disfigurement. What Ari believes by quoting this in her motion is she believes that just by having the idea that somebody, or having the belief that a fight may ensue, that it is okay for you to pull out your weapon and pew pew somebody. No, Ari, that's not going to fly. The courts and the judges are smarter than that. That's not the reason why she remains detained. She remains detained not only because she overreacted, she remains detained because by the simple action of what she did proves that she is a danger to the community. The simple fact that she shot someone in broad daylight right across the street from a school around several other people in broad daylight in a busy intersection is proof enough that she's a danger to the community. I don't know. So let's go ahead and read what the judge said as to why they were able to prove. And this was on December 4th. When the judge went through all of the, listened to both the prosecution, listened to Ari, looked at the evidence that was presented, the proffer, listened to both sides, even looked at documentation from previous court dates that Holly attended in obtaining her stalking order. The judge clearly explained why. Now, this is also what's going to be presented to the appellate court. What the previous judges stated, why they decided to keep her detained. Okay, so let's look at what the judge said on December 4th. Welcome in, Ebony. Welcome in, True Slayer. Shanta, spilling the tea. Hey, everybody coming in. So let's see what on December 4th, the reasoning that the judge gave for keeping her detained. Now, she's now trying to argue that in her motion or her to the appellate court, but the judge already explained very clearly why the state did present clear and convincing evidence. So let's go over, and those text messages, phone logs, phone calls with no number attached, just the name to say IDK, that is not evidence that is strong enough to be presented in a court of law. Really, it's bullshit, to be honest with you. Really, if you come to that what she presented is bullshit, is what it is. Phone logs, Instagram messages has nothing to do with the actions that took place on the day of September 8th. Whether or not, and I'm gonna read you guys what something else that the judge said too, as far as the relationship between Holly and Romika. I'm gonna read y'all something. It's interesting. But let's read this first. Now, what Ari is saying is that the state failed to prove by clear and convincing evidence that Ms. Johnson poses a real threat to the safety of the person or persons in the community. And we're going to get into what the judge said. What I say is that the state didn't really have to prove much of anything because Holly's already admitted that she committed the crime. She's already admitted that she fired the weapon. So now we have her, Holly, that's admitted to firing the weapon. And then you have several people who are saying that she was the aggressor in the situation and that she engaged in an argument and in a back and forth with the deceased. So that means that the law codes for the state of Illinois that speak on self-defense no longer apply to her. So that's something that has to be debated in trial. That's not something that's debated while she's pre-trial. They have to look at that evidence later. So the fact that there's a discrepancy on whether or not this was self-defense, this is the reason why she has to remain detained. Because she's saying one thing, but you got 5 other people saying something completely different happened. So this is what the judge said when he decided at the first court hearing that he wanted to keep her detained. He says, at this time, it is lower, and this is what I just explained to you guys. It is a lower evidentiary standard than that which the state labors under a trial, which, as most people know, is proof beyond a reasonable doubt. So knowing that standard, what are the 3 things that the state has to prove? Now let's get into it. This is what the judge really read her down. He really read her down. And unfortunately, the Holly Delulus really believe that this girl is going to walk free. So the Holly Delulu still thinking this poor thing finna walk free. But this is what the judge said, and this is why the motion isn't going to work. Are we still screaming that the state failed to prove with clear and convincing evidence? Okay, but this is what the judge said on December 4th, and then at the next court hearing on January 8th, what's the next court? I believe that was the next one. The judge said was basically what he said was very similar when it came to why he decided to keep her detained. And we'll go ahead over that on another day. We'll go over what the judge said on January 8th on another day as to why she remains detained, because you have to remember the appellate court is going to take that into consideration. Why did these previous judges decide, not one but two, to keep you detained? Everybody is not going breaking the rules here. Everybody is not not following protocol. There's a reason why these judges, not one but two, decided to keep this young lady detained, and they're going to look at transcripts. They're going to look at the rationale behind why these previous judges decided to keep her ass locked up. Shout out to y'all for helping me reach my goals. Shout out to everybody coming in the room. Thank you so much, Brianna Stanton. Thank you, hon. I think I said thank you to High Wings Lover. Thank you so much, Nikki Daniels. I was reading y'all, so I couldn't see this. Thank you, Dr. Q. I appreciate it. Thank you, Maya Deuce. Thank you for that membership, Josephina A. Stokes. Thank you for that. I appreciate it. Hopefully, I didn't miss anybody. I know I probably did. Okay, so let's get into it. Sandy Kane, thank you so much, love. Thank you, Shawnee. I appreciate that. So let's get into it. So this is what the judge said December 4th. At the same time, it is a lower evidentiary standard than that which the state labors under trial, which, as most people know, is proof beyond a reasonable doubt. So knowing that standard, what are the three things that the state has to prove? Number one, the proof is evident or the presumption great that the defendant committed an offense, which is eligible for detention pursuant to statute. Number two, dangerousness, whether the defendant poses a real and present threat to the safety of a person or persons or the community. And then finally, number three, conditions, whether or not there are any conditions or a combination of conditions that can mitigate the real and present threat posed by the defendant by their actions. Now, he's going to get into them one by one. Shout out to Erica. Thank you. Welcome to the membership, hon. You guys, I had to clean up my Facebook the other day. I'm still not done, but I cleaned it up. And now what I'm going to do now is I'm going to create a group on Facebook or a private page on Facebook where I'm going to send out invitations to you guys, or you guys can send in requests to join the group. I'm going to have to vet the people before they come into the group. Once we get past that process, then we can start back with our membership lives, because what's happening is I have people that are buying my membership just to play it on their channels. And the thing about that is a membership is something that you pay for. So I'm not going to have a paid membership and then other creators are literally buying my membership so they can play it to their audience for free. Absolutely not. This is a whole business over here. We running an actual business over here. So if you're paying for a membership, that means that you are going to be privy to things that are happening on my I'm going to be showing things that I'm not showing to everybody else. You guys are paying for a I'll say exclusive content that everybody else is not going to get. So that's not fair to you guys, that you guys are paying for something only for it to be played for everybody. So what I'm going to do is, after that group is created, I'm going to do all of my members only lives under an unlisted link. So the link will be unlisted, meaning nobody can actually see it. The only people that are going to be able to see my content with that link on that particular video are those people in my group. And that's it. Nobody else. So if you pay for a membership, I'm going to create my group on Facebook, and we'll start with the unlisted link, and we'll do our membership only lives that way. That way I don't have to worry about any creators buying memberships just to play it for everybody. Okay? Because that's not fair to y'all. And I appreciate y'all for actually, it might be $3.99 and that might not be a lot to, everybody, but $3.99 can be a lot to some people. And some people sacrifice $3.99 just to pay to watch something, or even pay to watch old videos that I've done, only for other people that didn't pay anything to get a chance to watch it. I think that's a violation and it's wrong. So I'm going to make sure I protect my videos, and I'm going to protect you guys' investment by doing this a different way. So just bear with me. I'm coming, y'all. I'll be real busy, but I'm coming. But I'm going to make my group. And we are going to get this thing rolling. Just give me a couple weeks, okay? Just give me a couple weeks to set everything up. So let's get back into what he said. So he went over all three prongs as to what's expected and why he's going to make his decision. Now, this is what Ari, in her motion to the appellate court, said didn't happen. So basically, she lied because it did happen. So then he goes on to say, as always, we begin with prong one. Whether the proof is evident or the presumption great that the defendant has committed an eligible offense for detention. So most of the information provided from the state's proffer, although the defense did provide information on their own behalf as well, including a court transcript, which the court was able to read in its entirety. Listen to this, y'all. This is what I really want y'all to pay attention to right here. This part that's highlighted in green. And the reason this is important is because social media, YouTube, bloggers, they're not professionals. They don't have degrees. They don't know anything about the law. A lot of us are just learning as we go, including myself. So you can't depend on a blogger to tell you or to explain things, how things are going to go in court, right? So when you see people taking the exhibits from the motion sent to the appellate court and say, oh my God, she called that man 50 times. The court, I'm telling you now, they're not going to care. It has nothing to do with whether or not on the day of September 8th, Holly Johnson was the aggressor or not. The question is, was she the aggressor on that day? And there are 4 people at this point that are saying that she is and was the aggressor on that day. That is what the court is trying to figure out. They don't care about no past stuff that she had between baby mama, baby daddy drama. That has not that baby daddy. Y'all listen to me closely. Baby mama, baby daddy drama does not mean that you should be murdered. Okay? Put some hearts in the chat if y'all agree with that. Baby daddy and baby mama drama does not mean that you should be murdered. Baby daddy, baby mama calling somebody 50 times does not mean that you should be gunned down in the street. So by showing the court a call log or text messages does not justify murder. Okay? I'm just letting y'all know. So this is what the judge said, and I'm sure this is what is going to happen during trial once Ari presents that bullshit at trial. The judge says, and it's right here highlighted in green, I just want to state, just make sure I don't forget on that transcript. It seems like, yes, there was a lot of back and forth. It sounds like both parties, there was bad blood. There's the allegations that the counsel alluded to, and then a page or two later, there's the allegations that the respondent had against the petitioner. So let's stop it right there. The judge is saying that regardless of what her supporters are putting on social media, it doesn't matter. In a court of law, it's already been acknowledged that these 2 young ladies have had bad blood with each other. Not only has it been acknowledged that they had bad blood between each other, but it's also been acknowledged that due to the dynamic of their relationship, bad blood oftentimes is to be expected due to how they know each other, meaning due to the fact that they share the same child's father. It is not unusual for 2 women that share the same child's father to have bad blood. This is not unique. So the judge is saying that this is not unique. He's also acknowledging that in this statement here, he's also acknowledging that not only does the transcript that Ari presented to the court show that Romika had bad blood with Holly, but it also shows that Holly has bad blood with Romika. He points out that there is a point in time that's on record where Holly contacted the Department of Children and Family Services and reported Romika and could have possibly had her child taken away, making allegations and reports that Romika's son had boils on her body. So on social media, they want to make it seem like the beef was one-sided and there was one woman that was so incredibly jealous of another woman that she had to kill her because the woman was so jealous of her and wanted her man back. That's what the social media will try to spin. But and they say that us Romikians try to do that. But it's interesting that they say that because I have a document that's in black and white on my screen. And I'm clearly reading the words of the judge, where the judge says there was accusations of, I believe, among other things, the one that stuck out to me just because of the uniqueness of the charge was the allegation that the victim's child had boils or something to that effect. So there was clearly bad blood between these individuals. Notice the judge is not pinpointing all of the aggression on Romika. Notice the judge is not because it's common sense. Notice the judge is not saying this is all Romika's fault and she was attacking and stalking Holly and Holly should have been scared for her life. No, the judge is acknowledging that he has read documents showing that in black and white that both of these young ladies were fighting with each other, whether it had been online, virtually, on the telephone. They both had bad blood. So when you listen to this content that tries to demonize Romika, please understand that they're just trying to spin a narrative, because in the court of law, there is no spinning of a narrative, because a lot of things that both of these young ladies did with each other before her untimely death has been documented. Thanks to Holly. Thanks to Holly for going to court for 7 months straight to get that stalking order. So now everything is documented. It shows that not only was Romika jugging at her, but Holly was jugging at Romika. Holly was not innocent. Not at all. Not at all. No matter how they try to make it sound, she was not innocent. So, and it's very easy to demonize someone when they're dead and they can't defend themselves, and they can't present their documents, and they can't present their call logs, and they can't get in contact with bloggers on social media and send in their evidence. It's easy to try to demonize someone when they're dead and can't defend themselves. So when you're alive, yeah, it's easy to make it seem like that person was the worst person to walk the face of the planet because they can't speak up to defend themselves. So we will be the voice for Romika then. We'll be her voice. And in doing that, we're going to read documentation here, where the judge is acknowledging that Romika was not, in other words, she wasn't arguing with herself. He then goes on to say, so there was clearly bad blood between these individuals, which is not terribly uncommon when we look at the context of how they know each other, which is they both have children, both of their children have the same father. And sometimes that situation creates conflict. It's part of the human condition, totally foreseeable. So let me stop it there. I noticed something that sticks out to me is when he says it's part of the human condition. It is very common for women to have jealousy amongst each other, especially when they have dealt with or are dealing with the same man. Now, we also know that Carlos admitted on a panel in the past that he had Holly pregnant, but he was off on vacation somewhere with Romika. Okay, he was somewhere dressed on the holidays in matching outfits with Romika, and Holly was off pregnant, barefoot and pregnant by herself somewhere. And looking on social media and seeing the man that has her pregnant with his baby mama and their son, and she's having to see that. So it is only natural that because you have a man in the middle that is obviously and admittedly, because he's basically admitted to playing both sides with both of these women. We witnessed it on camera where he was laying in the bed with Romika on vacation, Romika on the phone with Holly, and he laid back chilling, recording them. Like, so we know that he obviously was playing with both of these ladies, creating chaos. So it's only natural because people have feelings and people have emotions. No matter how many times you hear these women sit on these panels and try to pretend like, they've never been jealous or they've never been cheated on or they've never been played and they never snapped or went off or crashed out. Everybody's so classy. Yeah, right. So even though they try to paint that picture, the court is actually acknowledging that it is part of the human condition and totally foreseeable that conflict would occur between two women who share the same, whose children share the same father. So bump that bullshit that the content creators on social media are talking about. It say right here in black and white that the judge completely understands the dynamic of the relationship. Now let's continue. So then it goes on to say, so in any event, this defendant was able to get a stalking no contact order. And I just want to note what a stalking no contact order is. What it gives is sets up groundwork for an individual who is the petitioner and the possessor of that order. When there are violations of that order, to call the police. And that can result in charges. That's what an order of protection is. So the judge here is highlighting that a stalking note, because this is the narrative that the Holly Delulu spin. The narrative that the Holly Delulu spin is that because she had a stalking no contact order, she had every right to shoot her. And that's why their dumbasses are going to go to jail if they do the same shit, because that is not what a stalking no contact order says to do, and that is not what it gives you license to do. What it says is this person is in your space and they're not supposed to be in your space. And then it says to call the police. Actually, when you look at the documentation from the court orders from when she was going to court to obtain the order, it said more than 3 times for her to contact the police if she ever finds herself in the same vicinity as Romika. That is what the order told her to do. The orders from the previous court hearings did not say if you see Romika to argue with her and then shoot her. That's not what the order said to do. So then it goes on and says, and that can result in charges. That's what an order of protection is. A stalking no contact order is just a version of that. So now let's keep going. So then it says, so then we fast forward to September 8th, 2025. Rush hour, pretty much. And the reason I'm reading this, y'all, is because I'm showing you guys what this judge's rationale was. Tomorrow, I'm doing a live on a different topic, but then I'm going to come back maybe on Saturday, and we're going to cover what the other judge said, okay? He then goes on to say, rush hour pretty much. And apparently, the witness number 1, the aforementioned father of these children, with both the victim and the defendant, apparently lives, I believe I was told, 21-something state. So basically right around the corner from where the victim's child goes to school, which I believe was 50-something on Cermak. It's the corner of State and Cermak. This is a stone's throw from each other. The victim stops her car after she sees the defendant and the witness, and there's an argument that ensues. Let me stop it here. I'm stopping it here because the judge is acknowledging that there was an argument. And that's an interesting word, because an argument is not a berating of someone. It's not a verbal attacking of someone. An argument means is something that is mutual. An argument is something that you have to. Now, we do have people out here that argue with themselves, but I don't think that's what happened in this case. I think in this case that they were arguing with each other because that's what the witnesses said that they saw. So the witnesses said that they saw an argument, and that's what the judge is acknowledging. Then the judge goes on to say, now this is a busy intersection. Now it is rush hour. There's people all around. It is obviously broad daylight, and several witnesses are noticing what's going on. Again, I would notice that most of these witnesses don't know anybody. They have no stake in the game. They don't know the context. They're not shading what they have by life experience with the parties. They're just literally random bystanders who happen to be observing this thing. And then they tell pretty much the ones who describe it, it is all described pretty much the same way. That initially the father is acting in between the two females, trying to keep them apart. Everyone notes that the victim is unarmed. Okay, and at one point, the witness was pushing the defendant away from the victim. We're gonna skip down, y'all. Okay, we're gonna skip down and we're gonna get this to this part because the rest of what he's saying is what we already know. We already know what Holly did on that day. So I'm not gonna make y'all sit through all of that, but I do want to get to this point here. Let's skip down. Okay. Now this is where issue of self-defense. Okay, so this is where he talks about the entire incident. So he's covering at this point prong one. Now we're gonna go down where he talks about, now he's going through the prongs one by one. Whether the presence okay, he's going through the prongs one by one. And I think that that's important to note because each prong has to be covered very meticulously in order to show that this is the reason why the person has remained detained. So he then says it brings us to prong two. Whether the defendant poses a real and present threat to the safety of any person, persons, or the community, based on the facts of this case. I have before me a defendant who murdered the victim after the victim had just dropped her child off at school. Subsequent to the murder, the defendant celebrated in full view of witnesses at a busy intersection in broad daylight on the streets of the city of Chicago. The defendant was undeterred rather by the presence of witnesses, the fact that this was a public setting, the fact that it happened in broad daylight, the fact that it was near a school, which inherently is a place of children, the fact that her own child presumably was mere feet away, and again, even before the murder, this defendant, the witness actions at the very least got witnesses to call 911. I would also say the defendant has training and licensure in firearms, and that had no deterrent effect on what she did. The kill shots, the celebration, there's this twisted sense of self-defense. So I absolutely find that this defendant is a real and present threat to the witnesses as well as anyone who she thinks that their words, despite her training, despite the licensure, despite basically societal norms, this defendant has proven that she will exert deadly violence over verbal arguments. Anyone who is capable of that, not just having the twisted belief system, but the ability and willingness to act on it. Such an individual as this defendant is absolutely a threat to the community and to the witnesses. Now, Ari says that the courts or the previous judges did not prove that Quadesia was a threat to the community. But as you can see here, the judge goes over what she actually did shows that she's a threat to the community. The fact that no witnesses other than her boyfriend saw a fight shows that she's a threat to the community. So then he says, now this brings us to prong three. Whether there's a condition or combination of conditions set forth that can mitigate the real and present threat to the safety of any persons or the community. In order, the question becomes, what can I do to mitigate this threat? And the threat is, hold on one second, y'all. Hold on. Let me answer this. And the threat in this case is lethal violence. So now the judge, let me stop reading. Now the judge is faced with trying to figure out what would be the best form of detention to mitigate the threat of lethal violence. What can he do to mitigate that? So the judge goes on to say the most powerful tools to mitigate that that are available for me to impose will be some form of electronic monitoring. The thing about that is, especially in its current form, where it is not directly run by law enforcement, is how can that possibly mitigate that level of threat? It requires a great deal of buy-in and compliance with rules and the law to be effective mitigation. But this defendant showed an utter contempt for the law and basic societal norms when she executed the victim in broad daylight on the street, pretty much right outside of a school. Electronic monitoring and home confinement would not deter this defendant from harming the witnesses or anyone else she encounters that she will perceive as a threat based on their words, committing new offenses or complying with conditions of release. Because again, she has proven that she cannot abide despite deleting. Holly is not getting out. The judge's opinion is just that, an opinion after a hearing. The standard of evidence is low if it is not proved. But we already said that, Mike. We already said that because we're not at trial yet. So therefore we don't have to that burden of does not have to be proven. That standard of evidence doesn't need to be proof beyond a reasonable doubt. We're not talking about her conviction right now. Right now we're talking about her detention. So yeah, we understand. Okay, it's back now. So Mike, we're not talking about Holly's conviction. We're talking about Holly's detention. So right now, we're not talking about proof beyond a reasonable doubt. It is the judge's job to give his opinion. It is the judge's job to give his opinion on why she should remain detained after reviewing the documentation and after reviewing the evidence. So so there is no need to have proof beyond a reasonable doubt. All that's needed is clear and convincing evidence, which exists. So no rules were broken. So we are understanding that proof beyond a reasonable doubt has not been shown. We get that, but that's also not expected right now. So we're not looking at this documentation and saying, oh, look at all this. We're looking at what the judge's rationale was as to why she remains detained. And not only are we looking at it, but the appellate court is going to look at it as well. So back to what I was saying. Again, so let me go back to really what. Okay, so again, so this is being read because Ari said that the state failed to prove, which is why I use the word prove, by clear and convincing evidence that Ms. Johnson poses a real and present threat to the safety of a person or persons or the community. So this is what Ari stated in her motion to the appellate court. So that's what Ari stated. Really, there's nothing to prove. The only thing they have to prove is that she shot her. And she admitted to that. So he goes on to say, this is someone where there, this is what I was getting ready to say before. See, this is why I don't look at the comments. So the judge acknowledges where he says day after day after day after day in this county, and this is one of the few defendants who decided that ignoring going to the courts, she would execute the victim on the streets of our city. So he's saying that the dispute that Ramika and Holly had, which I agree wholeheartedly with. Oh, okay. Somebody said my sound is back out again. I don't know why it's not showing me. Normally, if my sound goes out or something, it will show me that my sound is out. I don't know what's going on with. Let me see. Yeah, it's not showing me. It's showing me. It's showing me that the sound is good. So I guess let me know if you guys can, because the last message that I read said that I was out or that my audio was out. So before I continue, I would like for somebody to let me know if you guys can hear me or not. Okay, you guys can. Okay, cool. So the fact that he said that stuck out to me, because that is very true. That the dynamic that Holly and Romika had with each other, baby mama, baby daddy drama, that stuff happens every day. People go to court and file bogus restraining or stalking orders and things of that nature every day, just as a retaliatory method, or just really as a form of harassment. You have people that literally go to the courts just to do that, to inconvenience someone because they're mad with them, or because they don't like them, or because they're going back and forth. But what the judge is saying here, and let me say this, the judge, there is a difference about just giving an opinion and giving an educated opinion. So I would say the judge is giving an educated opinion. And the reason I say that is because he's not just saying this is what I think just because this is what I think. He's saying this is what I think based off of the evidence that was shown to me. Evidence meaning the proffer, witness statements, also the documentation that Ari presented to the court at the initial detention hearing, which was all of her court documentation, or all of her transcripts from the court from December of 2024 all the way up until June of 2025, showing that she went to court like 6 or 7 times trying to get this stalking order. He read through those documents, and it shows in the documents not just what Romika was saying or doing to Holly, but it also shows what Holly was doing to Romika. So he's not just throwing an opinion out there. He's giving his rationale. He's explaining why she's going to remain detained. He's explaining the reason why he's come to his conclusion. It's not just, oh, because she shot somebody, so let's lock her up. No, he's giving a reason. And he's not just giving a reason based on his own bias. He's given a reason based on what has been presented. And as we know, what has been presented does not have to be proved beyond a reasonable doubt. We're not talking about a conviction here. We're talking about detention at this point, although I do believe that she will be convicted of first-degree murder. I've been saying, I remember I was saying that she would be arrested and charged with first-degree murder, and everybody was saying that she wasn't. Oh, that's not. But then when she did, then everybody was like, oh, well, she was overcharged. No, she wasn't overcharged. No, she was not overcharged. Because what she did, in my opinion, is first-degree murder. Just because you have a history of conflict with someone does not give you license to shoot them. Especially when you have several people who witnessed the incident and said that you were in a mutual verbal altercation with this person, arguing back and forth. So you were engaging in an argument. Then you got people saying, another witness saying that you weren't even anywhere near her when you shot her, which is also backed up by the medical examiner's report, which I'm getting ready to show y'all. Now, I'm not saying that this is 100% correct. I'm not saying it's 100%, because I'm not a medical examiner. I don't have a degree in that field, but I do know some of the basics from what I've researched. And in the medical examiner reports, it kind of verifies what the witnesses said. The medical examiner report says that there was no gunpowder and no stippling on her person. The witness number 5 said that she was standing on the sidewalk and was nowhere near Romika when she shot her. To me, that adds up to what the medical examiner report states. Because when you pew somebody at close range, I would think, now I'm not an expert, but just I would think, as a person that has fired a weapon before, that person would have gunpowder on them of some sort. That's just what I don't know. That's just what I think, but we'll get to that in a moment. So the judge acknowledges that this is not a unique situation. So let's move on. Oh, no, I don't want to move on too quickly, because let me read this part. He says, in family court, day after day after day after day in this county. And this is one of the few defendants who decided that ignoring to go to the courts, she would execute the victim on the streets of the city. Now, the judge calls it an execution. The judge is completely dismissing the idea of self-defense. And the judge called it an execution. Simply put, now we're on, I believe, prong 3. Simply put, electronic monitoring also gives movement to, if I were to impose it and say it could mitigate the threat, I would be saying that electronic monitoring and giving that person that degree of liberty to someone who thinks that a verbal argument justifies murder, and not just someone who has that belief, but someone who acted with lethal consequences on that belief. Now, let me say this, because a lot of people are like, okay, well, the judge is saying that she shot her due to a verbal disagreement. Well, it's kind of hard not to believe that she shot her due to a verbal, because you got people out here that are still saying that that Holly got beat up. You still got people out here running with that dumb shit. Not only did the girl refuse medical what is it? What am I trying to say? Medical attention or whatever. She refused medics. Okay. Once the ambulance got to the scene, she refused to be seen, and she refused a medical care for her son or for him to even be checked out. So beside that point, I always mention this because I want to keep mentioning it because I don't want you guys to forget. There are 5 witnesses to our knowledge at this point. 5. The only witness who says there was a physical altercation is the baby daddy. The other 4 witnesses who don't know any of the parties are saying they did not witness any physical altercation between these 2 parties. But what they are saying that they witnessed, I just want y'all to use y'all head for a minute. Matter of fact, put yourself in a situation, right? And I'm going to keep going back to this. Put yourself in a situation. If you are standing, if you're outside, right? And you see somebody and you've been there for a couple of minutes watching an altercation. When I say altercation, I'm talking about argument. And then all of a sudden the person gets pew-pewed. Don't you think if you are a witness to that you would also be a witness to the fight? The state of Illinois says that the threat of violence must be imminent in order for self-defense to exist. Imminence means that the threat must be happening in the moment. What threat was happening in the moment? Why did 4 people see a person get shot, but none of them saw the fight? If I see the shooting, I should have saw the fight too if it's imminent. Because if it's imminent, it means I'm being attacked and I pew-pew. That's what that means. It doesn't mean that we got into a fight 5 minutes ago, then we started arguing, and then I walked away, got my gun, and shot you because I didn't like what you said. That's not an imminent threat. An imminent threat means that I am actively being attacked. My life is actively in danger. It is a possibility that I actively, right now in the moment, may obtain serious physical injury that could potentially kill me. And now I have to stop it by using lethal force, or I may die or have serious great bodily harm to my person in the moment. It doesn't, nowhere, anywhere does it say that you can get into an argument with you can get into a fight with somebody 5 minutes ago, start a verbal altercation, and then walk away, get your gun, and shoot them. It does not say that anywhere in black and white. But this is what the witnesses are saying that they saw. So I'm just saying, I just want y'all to maybe sleep on that. Y'all got to use y'all common sense. If you were to witness a shooting, but the person that shot the person says that they shot them in self-defense, don't you think you would also be witness to what they were defending themselves against? How come nobody saw a physical fight? In none of the documents, in none of the transcripts, nowhere does anyone acknowledge a physical fight. The only place that you're going to see the acknowledgement of a physical fight is here on YouTube with the Delulus that are supporting Holly. That's the only place you're going to hear about a physical fight. When you actually look at the black and white, you're not going to see anywhere any acknowledgement that any, how many judges have there been so far? 2. There's only been 2. Yes, there's been 2. Neither one of those judges has even entertained the fact that or the thought that there was a physical altercation between those 2 women. I'm just saying. I've never heard of it. I do live in the state of Illinois, I did not know that you can shoot somebody because you think you finna get your ass whooped. I just never heard of that. But let's okay, so let's go on. So uh and not just someone who has the belief, but someone who acted with lethal consequences on that belief. The judge goes on to say, I give no faith that she would be able to comply with electronic monitoring, or that even she was able to comply given the way it was set up, that she would not be electronic monitoring would not in any way, shape, or form affect her apparently belief that verbal arguments justify murder. So what the judge is saying here is that regardless if she's on electronic monitoring, obviously her belief system is skewed. She believes that shooting and killing someone is self-defense because of verbal altercation. That is what she believes. So her being on electronic monitoring won't change that belief. And if it won't change that belief, potentially it won't change her future actions. That's what he's saying here. So then he goes on to say it cannot mitigate the threat that this defendant poses, and I'm going to respectfully grant the state's petition. Now, ma'am, also I should note, I was also told the defendant is, I believe I was told 7 weeks pregnant. Ari says yes. I don't even want to read that part. I don't care about that shit. Okay, I'm not going to read that part. Reason I'm not reading that is because I think it was a lie anyway, and it doesn't even matter at this point because from what I hear, she's no longer pregnant. Now that's up for debate, but I'm pretty sure she's not pregnant anymore. She's no longer placed in the women's unit for the pregnant women. I forget what unit, what division that was. 8, was it division 8? So then at this last paragraph, it says, if there becomes a time where the defendant is in custody and it looks like there is a chance that she would be given birth in trial, I will have blah, blah, blah. I don't want to read that because she's not pregnant. So then let me go down here. Let's see, what do I want to... Okay, let's read this last part. Well, no, let's go up here. So I'm trying to get past all this stuff about her pregnancy because I just don't think it matters anymore. They're talking about a healthcare order and stuff like that. So the judge says, well, let me read this. I guess I'll read this part. She says, the court says, any other orders? The Williams Ari says, yes, judge. She says, no, I'm not. I'm asking for a healthcare order. I do respect your ruling because, again, the judge ruled that to keep her detained, okay, obviously. She says, I just want to make this part clear for the record, judge. I think the case law goes against her not being detained. But, man, this Ari, she is relentless. I guess she's supposed to be. But it's like, girl, he says she ain't getting out good. But then she goes on to say, I think the case law goes against her not being detained based on this case only. Regarding the third substantial amount of case law, but I can handle that with the appellate court. On the next court, which she is, on the next court day, I will be seeking to review her detention. And then if I have to, I'll file an appeal for the... She put from, they put from, but I think she probably said for the appellate court. But that's all I have. I'll draft the healthcare order to you. So he didn't even ask her for all that, okay? He just asked her, was there any more orders? But she had to throw that part in there that basically he did not agree with her. She did not agree with his ruling and that she would be contesting it. He ain't asked you that, girl. But so So I'm gonna read y'all comments in a minute. Let me get past this one part. So the judge says, sure, as long as we're talking about the appellate court, I was taking inspiration from the case People versus Romine. I think I said that right. Roman or Romine. I'm gonna say Romine, 2024, where basically the court outlines ultimately the evidence of a defendant's charged content. Do y'all want to go over some of these cases that they're mentioning in the we can't do that tonight, but like on a different date where we can like kind of look at some of these cases that Ari mentioned in her motion and that the judge is mentioning here. He's mentioning People versus Romine. He says where basically the court outlines ultimately the evidence of a defendant charged contact, even if it took place on a single occasion, may reflect such a departure from the basic expectations of civil society that it becomes difficult to predict the defendant's compliance. Yeah, let me just say this. I had to stop reading because I just think this judge is really, really, he's sharp. I just think he's sharp. I'm not, Ari is too. I'm just saying though, he's sharp. Like well, I guess I can't say because he knows his stuff. He's a judge. He's supposed to know his stuff. But it's just the way that they just be, throwing these cases out. Like they literally get into, when you look at these transcripts, sometimes they get into like these little arguments based off of previous court cases or case studies, and like it's like they know them like the back of their hand, and I think that's just very impressive. So he says, Ari does as well, but he says where he's referring to People versus Romaine, he's saying, well, based on that case, even if it took place on a single occasion, may reflect such a departure from the basic expectations of civil society that it becomes difficult to predict the defendant's compliance with court orders or even societal norms regarding the safety of others. So I take inspiration from that case. And then Ari couldn't say nothing but thank you, Judge, because he's saying that based on that case, he takes his inspiration from that. And which basically is what he's been saying when he was going through the different prongs, especially the prong where he talks about electronic monitoring. And he's saying that just based on the fact that she has the belief system that it is okay to react with lethal violence based on a verbal altercation is enough to keep her detained. And electronic monitoring does not mitigate that threat. And so that's it. That's all I wanted to read from that, you guys. Let me look at the comments before I move on to my next thing. They definitely do, Evan. They argue with some class, okay? Missy said no because they have nothing to do with this case. Mike says, sure, I do case briefs for breakfast. Okay, so shoot, I would love to see. I've never done that on my channel, but it would be interesting to take some cases that they are mentioning in the motion, that Ari's mentioning in the motion, and then some of the couple of the cases that the judge from December 4th mentioned here, as what his inspiration was to reach his verdict. I would love to look at that. I think what was that case? It was, I'm gonna write that down. Shoot, did I close out the whole thing? I think I did. What was it? People versus Romaine, I believe it was. Oh, I didn't know I had that many people. Dang, y'all in here. Okay, late. And just imagine, y'all, I was getting ready to start right now at 10:45. I'm glad I started early. Thank you, Sierra Boy. Make sure that if you guys are in here, that you go ahead and hit the like button. It pushes me out into the algorithm. It gets more people in here so that they can hear my material. Okay, it builds my channel. So the like button is really important. Okay, so if you can hit the like button for me, I would greatly appreciate it. I also want to say thank you guys so much for helping me get to my goal of 10 super chats and super stickers. I do appreciate that. I'm going to pull something else up after I read a couple more comments. This one looks interesting. So, okay, Mike said Ari messed up. The appellate court kept the defendant detained in that. Did Ari mention that case? Or did the judge mention? Are you talking about People versus Romaine? So Mike is on. If you guys don't know who this is Brown Mike from Facebook. He's a CCL instructor, pretty well known in Chicago. A lot of people go to him. He also gives good commentary on the case. He's very non-biased. I would say that I'm a little more biased over here. I already know who what side I'm on. Okay, it is what it is. At least I can be honest about it. I know what side I'm on. Mike kind of looks at things from a perspective that can be offensive to some Romika supporters, and then sometimes some of his stances can be offensive to Holly supporters because his opinion is not set in stone. Okay, so he's looking at things objectively and looking at he's not on nobody's side. That's the best way I can put it. He's not on nobody's side. You know how you got the Romekians and then you got the Holly Delulus? Those are the teams over here on YouTube. Over there on Facebook, Brown Mike is very fair. He's not on the Romekian side, and he's also not a Holly Delulu. He just be talking about the case. So y'all not following him, go over there and follow Brown Mike because he does talk about it. I don't think he talks about it anymore, but I know he does. He was. Okay, the people of the state of Illinois plaintiff appellee Richard D. Romine. Thank you, sexy mama. Ebony. Thank you, Ebony. So let's pull this up. I want to see what you guys think about this. You know, I'm not going to really give too much of my opinion on it yet. But I just want to see what you guys think. So let me pull it up. Let me take my chat down for a second. I know y'all got to go to work in the morning. I do too. So I ain't going to keep y'all for too much longer. So here is a small section from the medical examiner report, okay? So it says here, just a small section, y'all. A gunshot wound of entrance on the anterior aspect of the left thigh measures 1/4 by 1/4 inch. The entrance wound defect is located 25-1/2 inches above the bottom of the left heel. The surrounding skin shows no evidence of soot deposition or gunpowder stippling. The I don't know how to say that. Hemorrhagic, I guess that's what the hemorrhagic wound path is through the skin, soft tissue, left femur fracture, and soft tissue. A deformed gray bullet, a deformed copper-colored projectile jacket, and a small red synthetic piece of material is covered in the soft tissue of the posterior left thigh. The bullet fragments are placed in a single sealed label evidence envelope and are submitted to a representative of the Chicago Police Department, and receipt is obtained. The direction of and then it goes on, which to a different sentence that I didn't capture. Okay, so the part that sticks out to me here is what I said earlier. Is we have a few statements from witnesses who are not in connection in any way to either party, meaning that I don't believe that they would be biased. How can you be biased if you don't know anybody? Okay, you don't know anyone who is involved. You're just giving your view, or you're saying what you saw on that day. Witness number 5 made the statement, okay, in her witness statement, that Holly was nowhere near Romika when she shot the weapon. Now, the reason I say that that's important to me anyway is because there is documentation here that suggests that her statement is true, in my opinion. It says here that the surrounding skin shows no evidence of soot deposition or gunpowder stippling. Now, does that mean a whole lot of? I don't know, but it does sound like to me that it kind of confirms, maybe not 100%, but it kind of confirms to a certain extent that maybe what the witness said is accurate. Because from my research and the things that I've read and the things I've watched on YouTube and the articles that I've read online, I'm not an expert, but from what I've researched, it does say that usually when a gunshot is up close or closer, that there will be gunpowder residue on the victim. And if a person is shooting from further away, there is a less likely chance for there to be gunpowder residue. So the reason that's important to me is because we have multiple witnesses that are saying that They were not in the middle of a physical fight at the time of the unaliving. So this is what I'm basically trying to say. So Mike says that report shows there was no and this is why this, and so I'm glad Mike is in here, because as I just told you guys, he is an expert on guns. He's an expert on weaponry. So he is a CCL instructor, and I would assume that he knows what he's talking about. I mean, even Mike, like I just told y'all, you can't say that he's biased, because he said things that the people that support Romika don't like, and the people that support Holly don't like some of the things that he said, because he just be honest about what he's saying. Even he, who is what I would consider more of an expert than I am on guns, he's saying that the report shows there was no close contact gun wound. The shooting happened at a distance. This validates what the witnesses are saying, which gives more credit to, or what makes the witnesses more credible, or that witness anyway, in my opinion. So Mike said he was at one point a homicide detective. He says, I attended autopsy before. We got somebody in here, none of your business, says Mike is and always has been a Holly supporter. That said, why is he always following Meek's followers? Holly intentionally killed Romika over a sorry illiterate bum. Well, Mike, you want to answer that? Tanya says, Upper, did they take BM's clothes and test them that day? How did okay, so that's what I'm about to get into. So the next part of this portion, or this section of the medical examiner report, says that a deformed gray bullet, a deformed copper colored projectile jacket, a small red synthetic piece of material is covered in the soft tissue of the posterior left thigh. Now, on that day, according to the black and white, I know in court at one point they said pink or something, but I believe she was actually wearing blue. So either way, she wasn't wearing red. So now the question comes into that. Matter of fact, I'm gonna ask Mike this question. The question comes into the matter as in, how do you think that small piece of red synthetic material got inside of her body? Because it was on the projectile, it was on the bullet. So Mike is in here, he's an expert. So how do you think that the red, because nobody was wearing red, I don't see how any red fabric would have gotten on the bullet other than from Carlos's clothing, because Carlos is the only one that was wearing red and black shorts. So Mike, how do you think that it happened? And I want to see what what everybody else thinks how you guys think it happened. Let me look at Mike said, I have 4.2 followers across all my social media pages. I don't know who I follow. None of your business. Say, I got beef with you now. What do you guys think? What do you guys think? Because I also think that I personally feel like this could also validate the claims that Carlos had Romika in a headlock, because he's denying that he ever had her in a headlock. Several witnesses are saying he definitely was holding her. He's saying that he wasn't. The question is, why would he be saying that he wasn't holding her if several witnesses are saying that he was? What would be the point of denying that? What do you guys think? So do you guys think that this shows that there was a red piece? They're gonna run it, right? So they're gonna check the DNA on the red piece of fabric. So whoever's clothing it was, they're gonna find out. Wherever the fabric came from, they're gonna find out. What's going on, Q? You ain't starting no trouble down there, is you? Was it blood from her wound? No, I think they would know. No, they would know if it was blood. Now remember, this is the medical examiner, so they would know if it was blood. So what they're saying is that this is red fabric from and fabric would come from what, a piece of clothing or something, right? So they're saying that a red piece of fabric was connected to the bullet, and the bullet was inside of her body, meaning that before the bullet entered her body, it had to connect at some point in time with a red piece of fabric. which I think is pretty normal. I think that when a gun, when a bullet is ejected from a weapon, before it enters its target, I would assume that as it's going, as the bullet is flying, it's picking up all type of particles and dust and even fabric, hair, all type of stuff sometimes before it enters its destination or its intended target. I think that bullets pick up a lot of things as they fly, dust, particles, all type of shit. But the fact that it picked up a red fabric is very interesting to me because the only person that was wearing red on that day was Carlos. Could have happened when they allegedly moved her. I don't think it could have happened when they moved her. The reason I say that is because the fabric was attached to the bullet. The bullet was already inside of her body. Mike says the beginning of the medical examiner report says that what Romika was wearing, it could have been her underclothes. Because on January 8th, for some reason, I remember I got to look back at my transcripts, but I remember the judge saying it looked like she was wearing pink. Oh, okay, her underclothes were blue. Okay. I'm about to say, I know it says blue somewhere. Okay. Yeah, Tim, it wasn't blood. Okay, so let's see what Mike's saying. So the red piece of synthetic fabric, piece of material inside the wound can be consistent with whatever it impacts under Lokert's principle of evidence exchange. Let me go look that up. What is that? I don't know. Let's see. Let's read it, y'all. Let's learn together. Let's learn together before we get off, y'all. Okay, let me pull this up. Where is it? Okay. So it says here, Lockert, is it Lockert's? I'm going to say Lockert. Lockert's exchange principle formulated by Dr. Edmund Lockert states that every contact leaves a trace. It posits that whenever two objects come in contact, a mutual transfer of material occurs, forming the foundation of modern forensic science. This principle enables investigators to link suspects to victims, scenes, and objects through physical evidence. Significance and use of forensic science, trace evidence transfer. When a criminal enters a scene, they leave behind traces, e.g. hair, fingerprints, DNA, and take evidence from the scene with them, which could be soil or fiber. Crime scene reconstruction. By analyzing these trace materials, forensic scientists can reconstruct the actions that occurred. Connecting suspects. It allows for the connection of suspects to victims or locations, as seen in cases like the Golden State Killer, where minute evidence was key. Types of evidence. Examples include hair, fibers, paint chips, glass, skin cells, blood, and DNA. Applications in digital forensics. Physical evidence used for analyzing fingerprints, footwear impressions, tire marks, and ballistics. Digital forensics. The principle extends to cyber investigations where contact involves digital interactions. This leaves behind digital trace such as IP address. I don't want to read all that. So it says limitations and criticism. Evidence dynamics. Evidence can be altered, contaminated, or destroyed before collection. Time and environment. Environmental conditions or time can cause trace evidence to degrade or disappear. Not definitive proof. While highly indicative, trace evidence alone does not automatically prove guilt, and it requires careful context dependent analysis. So I know I got into a lot right there, but basically, I wonder if I could play this.
This is a game about life, credit, and second chances.
Often called the Sherlock Holmes of France, Dr. Edmund Locard proved that no crime scene is ever truly clean. Locard's principle states that whenever two objects come into contact, They exchange materials, even if just tiny fibers or DNA. This idea, introduced by Dr. Edmond Locard, revolutionized crime scene investigation and influenced modern forensic techniques. Every contact results in material transfer. For example, a suspect entering a room may leave fibers behind or pick up dust. Materials include soil, paint chips, or glass shards, which can link a person to a scene. Hair, skin cells, or fluids can provide DNA. Digital traces. Cyber forensics uses digital footprints, metadata, and location tracking as forensic evidence. By analyzing these exchanges, investigators reconstruct events and establish connections. Here is how Locard's principle is applied in forensics. A thorough collection of trace evidence helps crime scene analysts reconstruct events. Trace materials on a suspect's clothing or items can link them to a crime. Advances like high-sensitivity DNA analysis and digital forensics enhance evidence detection. Emphasizing trace evidence transformed investigative approaches and became a core principle in forensic science training. Forensic science also strengthens investigators' credibility in court cases. Like many things, Locard's principle has its limitations. Environmental factors, time, or cleaning may erase traces. Trace evidence alone isn't proof of guilt. Context matters. Advancing methods require continuous refinement. Not all trace
I don't know if you guys could hear me, but I was talking. But what I was saying was, I think that video brought a little bit of clarity versus me just reading. So thank you for educating us on that, Mike. Barbara said the very first 911 call said a male in black and red is the. Is that what the first 911 call said? I don't know. I don't remember that being the first 911. I gotta do my research on that. I do remember somebody on the crime scene saying that. I don't know if the 911 call said that. I could be wrong. Every time you touch something, you pick up some and leave something behind. A purple butterfly says Trina just had a live on this. She played a video. It is the type of bullet that police use. Tanya said could have already been on the bullet before being loaded in the gun. Maybe was laying on something red. That's true too. Whatever it is, I think they're going to find out by doing testing on the fabric. So I definitely think that whoever the fabric is connected to, whether it was just laying on something or whether it's connected to a person, I think they're going to figure that out. You say yes. Oh, Keys played it. Okay, I got to go back and look. I might have missed that. Okay, guys, I'm going to go ahead and get off. I enjoyed you guys tonight. Thank you so much for joining me. Let me just say this. I know I say it a lot, but I want to say it again. I have to say that I am so grateful for all of you that come and watch my content every time I go live, no matter really what the topic is about. Because I was just live the other day, early in the morning. I had gotten up early. I said, I want to talk to my people. I hit the live button. I think I was talking about cleaning chicken. I was talking about cleaning some chicken, okay? And it was over 200 people in the room on that morning. I think it was 6 o'clock in the morning. So I just want to say that you guys' support does not go unnoticed. I really appreciate y'all. If it wasn't for you guys, I would not have what I have. You know, I wouldn't have the Upper Echelon podcast. I wouldn't be on the level that I'm on if it wasn't for y'all. You know, this channel is y'all's channel. Because of you guys, I am who I am on this podcast. So I just want to say thank you all so much for your support. No matter what I talk about, you guys show up and show out. Thank you so much for helping me reach my goal of 10 super chats and super stickers. You guys are really appreciated. Make sure that before I, or it doesn't matter before or after, just make sure that you guys hit that like button, okay? Hit that thumbs up for me. Also make sure that you hit the notification bell so that you are aware of the next time that I go live or post content or even a community wall post, anything that I post, by hitting the bell and then selecting all, you will be notified of anything that I post at all times. It's very crucial that you do that, because I never ever, for the most part, I did this time, but for the most part, I don't usually schedule my live streams because people steal your idea. If you post that you're going to go live about something, somebody else will go live about it. I mean, it's a dog eat dog world on YouTube. Okay. It's a dog eat dog world. So I usually don't do that. I like to keep the topics that I'm going to talk about to myself. This time I went ahead and scheduled it. But just make sure you hit the notification bell. Also subscribe to my channel if you're in the chat and you are not subscribed to me. I don't know what you're waiting on. You like this channel over here. You enjoyed yourself. Go ahead and subscribe. And that's it. I just want to say you guys have a wonderful night, and I will see you guys tomorrow with a different topic. Okay. So the next live is going to be for my LaTruth supporters. So I will see you guys later. All right, y'all. Peace.
Hey, I got a lady. Hey, I got a lady. Hey, name is the upper echelon. She a debater, baby. She can give it to you straight, no chaser. She got the smarts. She got the heart. She got the confidence, baby. Baby, she the upper echelon. You know you intimidated.